So, my name is David Cobb. As Barry said, I've had the privilege of speaking to the Eastern Property Rights Association a decade ago. And I have actually given presentations to Occupy encampments and to Tea Party groups.
Good.
Because, like Barry, I believe that there is actually a Venn diagram of politics. I actually believe that there is a way for us, on a principled matter, to find agreement. So I'm going to request your indulgence. Give me the opportunity to lay out where I think there is actual principled agreement. Because I promise you, if you want to look for disagreement with me, we will find it like that, very quickly and very easily. I am a liberal. I am on the left of the spectrum. I mean, Barry and I know each other. We could easily begin to list off the policy proposals where we have differences. And you know what? That's okay. In our Republican form of government, there should be vigorous debate and indeed disagreement on policy proposals. So I'm going to ask us to put aside our policy proposal differences for a moment and focus on, do we have agreement on the principle of self-government? Do we have agreement on the principle of a Republican form of government? And see if we can actually get that agreement. That's my challenge in a very short time. And in order to do that, I want to make sure that we cover four big concepts. The first is sovereignty. And for my purposes, I'm going to define that as the ability to govern or rule. And in this country, we the people are supposed to be sovereign. The king isn't sovereign. We kicked him out, remember? The second concept is legal personhood, which means, in essence, the ability to assert rights under law. That really, in a nutshell, is what that is. And that's why it's important. This is not a technicality that only lawyers should concern themselves with. The concept of who has the authority to assert rights and have those rights respected under law are a very critical and important concept. The third concept that we're going to cover is the distinction between a constitutional right and a statutory right. Because after all, if we're talking about the ability to assert rights, it would be worth asking, what is the difference between those two, if in fact we think there are a difference. I'm being very candid. I think a constitutional right is an inherent, inalienable right, which is how the founders talked about it. A statutory right is one that exists under law or statute. Those are different. A constitutional right is to be found and can be protected by our constitutional form of government versus a statutory right, which you must be able to point to a law or a bit of legislation that creates that right. The fourth concept that I want to make sure we cover is the idea of judicial activism, which in essence is the concept in which courts impose their will over and against the legislative authority of either elected representatives or, as in the case that Barry is proposing, the highest form of legislative authority in a Republican form of government, when the people themselves actually legislate, which is in fact allowed at the statewide level. Many states have the statewide initiative where you can qualify legislation for the ballot and then take it directly to the voters to vote. Barry has found a very unique, and I, as a lawyer, I will say, a very clever and absolutely legal way to change the charters of city or county government in order to legislate through the chartering process. So good on you, Barry. That's actually very clever. So those are the concepts I want to cover. Now I'm going to jump to the supreme law of the land, the document or the charter that is supposed to be how our government operates. What's that charter called?
Constitution.
Thank you, sir. The U.S. Constitution. How many of y'all have read the Constitution? I thought a couple of hands would go up in this crowd. So I will submit, when you read the Constitution in its entirety, you'll see two big concepts. The first concept is the most important concept. In fact, it's so important it's the first three words.
We the people.
We the people. Those are hallowed words in this country, and they should be, because we the people come together to create the second concept which is government itself. Saying it this way, we the people create government. Government is dependent upon we the people. In fact, I like how some of my friends say it. The people should never be afraid of government. Actually, they say government should be
Afraid of us.
afraid of the people. How many of y'all believe government is afraid of the people? I do. And you know why? Because if the government is not afraid of us, why are they spying on us? Because the reality is, whether it is that ever since Dwight D. Eisenhower was president, whether it was a Democrat or a Republican in the White House, whether it was Democrats or Republicans in charge of Congress, scientific, good polling and scientific research is able to demonstrate an increasing surveillance over the people of the United States of America. So-called dissident groups, which, by the way, is our constitutional right to dissent in this country, are literally being spied upon by the American government. So I actually submit to you that actually government is actually quite afraid of an educated, active, organized people. In the U.S. Constitution, we the people create government because we the people are understood to be free and sovereign. What does the word sovereign mean again? The authority to rule. See, we the people rule. Government does not have the authority to rule over the people. Government, in fact, is supposed to be subordinate and accountable. Government is supposed to be subordinate to whom? The people. Government is supposed to be accountable to whom? The people. That's how it's supposed to work. We the people are free and sovereign. Government is subordinate and accountable. And we the people are understood to have rights. Government does not have rights. Government only has duties. And as a lawyer, I'm going to stop for a moment to underscore something. The difference between rights and duties is very profound. You see, Barry, if you have the right to do something, it means you can do it. And you don't need my permission. You don't need this group's permission. You don't need the city council's permission. You don't need the state legislature's permission. You don't need Congress's permission. A constitutional right is sacred. It is sacrosanct. It is not dependent upon the political process at all. This is a very important idea. Government does not have rights over the people. Government has duties to the people. Duties are responsibilities. Duties are things that you are required to do. Government doesn't have rights over the people. Government has duties and responsibilities to the people. And where do those duties come from? Well, remember, all power resides with the people. In fact, the founders said explicitly, clearly, and unambiguously, no government is even legitimate if it does not have the consent. Can I go through the presentation? And it can have, no government is even legitimate if it does not have the consent of the governed. That is at the very heart of American political theory. We the people hold all the power. But that leads me to this quick pop quiz question. We're in Houston, Texas. What is the population, more or less, of Houston, Texas?
2.1
2 million. 2.1, even more precise. Thank you, sir. So 2.1 million people hold the political power of Houston. But I would tell you, and that's a true statement, I'll honor that statement, but I would hate to go to a meeting of 2.1 million people to decide where should stop signs go. And I like political meetings, but I'm not going to that one. Can you imagine the chaos? Because not just stop signs would have to be determined. You'd have to decide, well, how will we handle wastewater? How will we handle fire protection? What should we do? Like, all of the municipal responsibilities of government cannot be gathered to, you can't bring 2.1 million people to make all those decisions. Because in the American political concept, we the people do hold the power as sovereign citizens, but we wisely delegate a certain amount of our power to government. Do we delegate all our power to government?
No.
No, absolutely not. We only delegate enough power to government to perform the duties that we the people have told them to do. And how does government perform those duties? They write public policy and public laws. And that's as it should be. And in case you haven't noticed, there will be disagreement in public policy and public laws. And again, that's okay. We should actually embrace the ability to have vigorous intellectual debate and discourse and disagreement over public policy, and at the end of that debate be able to actually shake hands and say, I completely agree with you, but I respect your right to have that opinion, and we'll fight it out in the court of public opinion. That's one of the things that I have always admired about Barry Klein, his ability to vigorously debate his perspective on policy issues and still treat his opponents with respect. We are losing something in this country because too few of our elected officials and too few of the candidates seeking our office are capable of doing what Barry and I just did. And I challenge each of you to try to find it within yourself to do that, because at the core, we cannot have a Republican form of government if we cannot vigorously disagree and do it agreeably. But the other thing I want to point out is, whether you would agree or disagree on public policy, the one thing that no public policy can ever do is to violate the private rights of any of the individual citizens. And now that I've taken this time to lay this out, I will tell you in one sentence how I believe the U.S. constitutional republic is supposed to operate. Now, it's a run-on sentence to be sure, but it's still just one sentence. Watch this. In the U.S. Constitution, we the people are free and sovereign because we hold all the political power. But we wisely delegate a certain amount of our power to government, which we will always hold to be subordinate and accountable, and we will charge government with the duty to write public policies and laws, which they will do at the local, county, state, and even federal level. But the one thing that no public policy or public law can ever legitimately do is to violate the private rights of the free and sovereign people who live under our Constitution.
Wow.
Ta-da! Right? I mean, listen, I think this is brilliant. I think this is beautiful, because whether you are a liberal or a conservative, whether you are a Democrat, Republican, Libertarian, Green, what this principle does is say we have individual rights that are sacred and sacrosanct. We have a governmental system by which we will make decisions in a public arena, but we will never allow the majority to violate the private rights of the minority. This, my friends, is brilliant. We should try that in this country, because this would totally work. And I'm not joking.
We already have it.
This is brilliant, but we don't actually operate this way. Because before I go one second further waxing poetic about the Constitution, a quick time out to ask, somebody tell me what year the Constitution is ratified and becomes the supreme law of the land.
1788.
1787 was the Constitutional Convention. 2 years later it's ratified. But you're on the right track, sir.
Right.
That's right. I wasn't a gotcha game. But you're right. You focused on the Constitutional Convention, the creation of this government. It did take 2 years to ratify it, to replace the Articles of Confederation. I want 1789 on the board, though, so that we can now ask, in 1789, now that we understand that legal personhood is the ability to assert rights, in 1789, who could assert legal rights under this document? What were their characteristics?
Like citizens.
White, male,
Oh, right. Landowners.
property owners. The point is this, my friends, there is nothing that I would critique about this basic framework. I would say that in its implementation, the definition of who was a legal person was the problem, because indigenous human beings were not held to be people, not with constitutional rights. Because women were not held to be people with constitutional rights. Certainly the enslaved Africans, who were not people, in fact, were held to be property themselves, were not considered. So the problem and my critique of the framework is not over the constitutional system or idea. My critique is on who is defined as a legal person and who defines that. And I'll submit to you, it took mass movements to actually change that legal definition. It took mass movements to actually guarantee that women would have the right to vote and would be considered people. It took mass movements to abolish slavery. It took mass movements to actually change that concept. Lastly, I will now ask, does anybody know what it takes to form a corporation in Texas? Articles of incorporation. It's actually quite easy to do. You don't even need a lawyer. Lawyer will tell you this. If you're reasonably educated, all you have to do, I think the filing fee is $150 bucks. Yeah, you file your Articles of Confederation. It's $150 bucks, and as long as that you filled out the paperwork correctly and your check clears, a clerk at the Secretary of State, probably making minimum wage, will literally rubber stamp it and issue you articles of incorporation. You know how long your corporate charter can last in Texas today? Correct, forever, right? As long as somebody pays the annual filing fee and makes sure that the paperwork is up to date. That's true in every state in the union today. You know what you can do with a corporation under the Texas Corporation Code? Answer: the same thing you can do in every state. Anything legally permissible. That is the concept of the corporation. We have been trained and taught to think as if this construct known as a corporation, which is just a legal fiction, actually somehow is inevitable. But the reality is it's not. It is a construct. It is an idea, and it's a very important idea and one that I actually support. But here's the thing. I'm going to take us back to 1789 and tell you what, in the founders' mind, it took to form a corporation. Because it's not just in their mind, this was the law. First, your application did not go to some trivial clerk. Your application actually went to the State House of Representatives, where they discussed it, debated it, voted on it, and you had to get a majority vote. That's not enough, because after that, your application goes to the State Senate, where they discuss it, debate it, vote on it. You got to get another majority vote. And that's still not enough, because after a majority vote of the State House, majority vote of the State Senate, your application goes to the governor, who considers it and has to be willing to sign it. Does that sound anything like a corporate charter today?
No.
Of course not. What did I just describe? Majority vote of the State House, majority vote of the State Senate, governor signs it.
A law.
A law. Richard, the point is the founders of this country understood that a limited liability corporation was a privilege, not a right. Because you are allowing a limit on the legal liability and responsibility. So that's something that was very narrowly done. Yes, there may be reasons to do it, building roads, building canals, projects that needed to facilitate and encourage activity to bring together private resources to put to some public use, but it was not a right to create. Oh, and by the way, in the Founders era, and for 150 years, if a corporate charter was granted, it was typically only good for 5, 10, at most 20 years. Right. Basically, the lifespan of a merchant. And at the end of that time period, the limited liability concept evaporated. Now, the business could continue, but the concept of limiting your responsibility under law was limited in time. Oh, and get this. As you applied for your limited liability corporate charter, you had to prove that there was some public need for that limited liability. And if you were granted your charter as a privilege, not a right, all you could do was that specific type of business. And if you did any other type of business, you know what happened to your corporate charter? Revoked. Corporate charters were routinely revoked for going ultra vires. In Latin, that means beyond the authority, because the founders understood that they were authorizing this limited liability corporate charter in order to do things. And check this out. Even if you were operating in your narrow time period, even if you were doing the specific thing that the corporate charter had been allowed to do, if you were ever held to be violating the public trust or the public interest, guess what happened to your corporate charter? Revoked. Corporate charters were once routinely revoked in this country for merely acting outside the public interest. Which leads me to this pop quiz question. Does anybody believe that a single one of the Fortune 500 corporations or one of the big mega corporations of today could even operate under the political restrictions that the founders put on these entities?
No way.
No way. Now here's the thing, Richard. There are hundreds of thousands, probably millions of corporations that would continue to exist because most corporations are merely ways of mechanisms to actually conduct business. Let me be clear, Move to Amend is not opposed to the concept of the corporation, not opposed to the idea of doing business or doing business under the corporate form. But here's the thing. We do think that the founders' original intent of the corporation was a brilliant idea and should be used according to the founders' idea. Because now that we know that it takes an action of state government to create the corporate charter, we understand that the corporate charter can be used to hold the corporation subordinate and accountable. We understand that the corporate charter describes the duties of what that entity can do, and we understand that a corporate charter should only be allowed to exist if it facilitates the public good, or at the very least doesn't harm the public. And so there, my friends, I thank you for your patience, because here comes the punchline. A corporation should go here, as the founders treated it, as it was understood under law for over 100 years in this country. And here comes the punchline. When the U.S. Supreme Court, in an act of supreme judicial activism, by the way, creates the concept that says, no, you no longer create a corporation as if it's a legal fiction created under the laws of the state, creating statutory rights and statutory privileges. You now must treat a corporation as if it's a human being with inherent and inalienable rights of human beings. With those same rights, it perverts the whole thing. So I'm coming to the end. I see that you disagree, but...
Well, but you're skipping the biggest part of this, is that the reason why the corporations exist today is because it's the power to tax the corporation. And if you want to get rid of the power to tax the corporation, I'll sign up.
Okay.
No, let me. I think you want to make your presentation first.
Well, I was going to, but I can see that I'm losing the crowd, so I'll
I
just...
think you're right on. Please finish.
You know.
You are saying so well.
Are you aiming at Citizens United? Is that your aim?
No.
Okay.
This is the point. I think that some of you are already saying, he's a liberal, so I disagree with him.
Right.
So I'm not even bothering to talk to those people, because people who have already shut your mind, I already know I can't have a conversation. What I am saying is this. These concepts that I've just described are the principles of self-government, how it's supposed to operate. Because the concept of corporations having inherent and inalienable human rights is nowhere in the Constitution. In fact, I challenge you to find it and show it to me within the four corners of that document. The court created this concept out of judicial activism, pure and simple. And whether you like or dislike that concept, you should at least acknowledge that it is not a legislative pronouncement.
What case are you citing for that creation?
Santa Clara versus Southern Pacific Railway.
Is this aiming at the Citizens United decision?
It has that impact. It has impact on a lot of cases.
David, are you prepared for Q&A now?
Let's just jump right into it. Go ahead. I know that you wanted to jump in earlier.
Yeah, regarding the Constitution and the federal system, we had a dispute over, Bundy and the ranchers out in Oregon, who, they occupied a nature preserve, and over half the land in the West is owned by the federal government. Can the federal government, or does the federal government actually own that land, and do those people have a right to graze their cattle there if it's not owned by the federal government?
Well, the question of who owns it, I would have to research that way more than I have. I honestly don't know the answer to that question.
I would think the federal government could own or be said to own land.
Oh, well, clearly that's true. I presume that is true. That is certainly the argument. And in fact, yeah, so I presume that that's true.
Yeah.
But I don't know the answer. So let's do this. Raise your hand if you want to make a comment. We'll go 1, 2, 3. Barry, you'll be 4. So we'll just do those and we'll try to have a conversation. Who's number 1?
Okay. I find it very interesting, the constitutional background in terms of creating corporations and how we used to create corporations, what their relationship to the Constitution was. And I wonder if you'd be willing to trade off with someone else the doctrine of enumerated powers. We'll get started enforcing that according to the Constitution if you want to enforce the creation of corporations according to the Constitution.
Of course, I think that we should be enforcing the concept of enumerated powers.
Okay. Well, there are a few enumerated in the Constitution which aren't very many, and which would certainly reduce the size of the federal government by at least 95% if we followed that doctrine. So I'm just interested if you like the original Constitution.
Well, when you ask me,
willing to do that.
when you ask do I like the original Constitution, frankly, parts of it. I don't like the part that actually said that codified the enslavement of Africans. Did you like that part?
No, not at all.
Right. So the point I'm making is I think that I agree with Thomas Jefferson, who said every 20 years this document should be revisited. You know why? Because Jefferson believed every generation had the authority and responsibility to actually determine how our society should be operating, and that we should not simply slavishly adhere to what the founders, had done, or anybody else. But I'd be willing to have that conversation.
I mean, there is a process to change.
There is indeed. There is. And so the process...
There is a movement for an Article 5 convention.
There is indeed. And the way to do that is in Article 5. There are two ways to do it. Either you get 2/3 of Congress to make a proposal, or you get 2/3 of the states to call for a constitutional convention. Move to amend is actually pursuing both of those at once. We completely agree with that. But I also want to point this out. There is one way that you can amend the Constitution that's actually not in the Constitution and is actually done all the time. You know what that is?
Judicial activism.
Judicial activism, a court decision that actually says what the law is supposed to be. And I will tell you this, again, whether you are a liberal or a conservative, whether you are a moderate, whether you are a Democrat, Republican, Green, Libertarian, or an independent, there's a phenomenal book called The People Themselves. It is written by a law professor who actually argues that we should research and understand the concept of popular sovereignty and actually begin to engage in a way that actually treats ourselves as if we have more power. Because the reality is, the problem today, most Americans simply obsequiously, obediently accept whatever the courts have said we're supposed to accept under law. And I don't agree with that. Who's number two? Yes, sir.
Are you saying that under this that the state government couldn't change the laws to issue corporate charters for 5 years, or that they couldn't change the law to require them to submit to public duty? Or
I am not, Wayne. In fact, that's why the difference between a constitutional right and a statutory right. As I said, the creation of the corporation is actually a function of state law. And it is actually, like right now, and Barry, with your clever mind and organizing ability, it might be interesting for you to take a look at the corporate code and look at how corporations are actually being treated. Because if you want to look at crony capitalism, there's a place where you'll find it. And that cuts across, again, any of them. So I actually think that the states do have the authority and responsibility to create statutory rights on what corporations can or cannot do. A constitutional right, though, is different than a statutory right. What I'm saying is your rights to assemble, your right to speak, your right to worship or not worship as you choose to do, those are constitutional rights. They are sacred, they are inherent, they are inalienable, they don't depend upon the will of the legislative bodies. In fact, some would argue that the Constitution doesn't create rights at all. It just recognizes rights, inherent and alienable human rights. Statutory rights are different. They are created under the legislative process. Does that make sense? Because that's an important distinction.
Well, another distinction I think with corporations is that because I looked into this myself, if I wanted to form a corporation, I can't go up here as, because I run the corporation, I can't appear in a court of law. I have to hire you. So that's a very big difference. I was wondering also, though, how did, within any of this, you haven't talked about how corporations became to have human characteristics like feelings,
Well, they don't, of course.
Well, they sue in court for harassment. And
how
so
about
on.
that?
And how can they, how did they get that emotional feeling?
Wayne, here's your difficulty. You are attempting to use logic and the rigor of your intellect to apply to a concept that does not make any sense. Corporations do not have the inherent and inalienable rights of a human being, as actually the jurist William Rehnquist said, to confuse, corporations have a lot of import in our society, but to ascribe to them the rights of a human or the ability to think or reason or feel is to confuse metaphor with reality. So I actually am in agreement with you on that point as well. Who's number three? I think it was you, Richard.
Okay. I'd like to say I am so impressed with what you presented as a person that has spent a lot of years reading and studying the Constitution. I have come to the conclusion you have where the power of a corporation is a government power that has been commandeered by private individuals that no longer have to follow the rules of the Constitution. And but at any rate, and I'm seeing in this audience, people are stuck in a paradigm where they have been trained for a long time not to understand what the Founding Fathers talked about. And I've taken more than one class getting down to that level. And the corporation, when it got to where New Jersey, as I recall, was one of the first states to introduce it. And the first corporation, I believe it was the family or one of the big guys, they flooded the state with taxes. That state became super rich because of all the taxes. And other states wanted to get on that bandwagon, kind of like gambling is today. And it went right. And then once they got all the states on board, they cut the taxes out. Nowadays, the corporations, we give them more tax breaks because they have the power. And I wish you'd continue on to explain the personal, where the difference between a person and a human being. You know, where, like you said there, the person has the rights, but they're not alive. And let me summarize. How would you like to play a game of poker or Monopoly with me? And I'm going to make the rules as we play the game. How many want to gamble with me? You know, of course you wouldn't. And the problem is that's what he's talking about. We have forgotten what the rules are. Anyway, I know I'm talking too much.
It's all good. So Barry, and then this gentleman was next. Go ahead, Barry.
I want to comment on the issue of the federal land. As I understand the process, each of those states had a negotiation process before they came into the Union. And so the states had some rights vis-a-vis the federal government, but there are also existing property people on some of that property. They're called inholders, and they had their own rights. So it's very complex and probably varies from state to state. Well, I think what you described here is what we see happening in all cases, which is powerful entities get to rewrite the law because they have influence on who's actually sitting on the judiciaries of these various states, and of course the U.S. Supreme Court as well. And so the power is growing, and so now over time the corporations have more power than were initially envisioned. Now, the only argument I can recall that makes sense that we give them those rights is that a corporation is a collection of individuals. And so as individuals, they have rights, and the corporation is able to express and exercise those rights. What's your counter argument to that?
So I will say, Barry, and Ruthie can attest, because you've actually just in a very concise way given what I believe is the single best argument for why corporations should be treated as constitutional rights. Now, I'll be honest, it doesn't pass the muster for me, but you have done the very best one can do. In other words, if everyone at this table we all agree have individual human rights, if you all invest some money and go through the state chartering process and create a corporation, that somehow your individual human rights should be ascribed to the corporate form. Is that fair, Barry? So here's why. So that's the best case argument for why a corporation should have inherent inalienable constitutional rights. But here's why, for me, that doesn't work. Because your inherent inalienable human rights are human rights. You have them because you have an intellect, because you are conscious. Some people would say you are endowed by a creator, whatever you conceive of that, with those constitutional rights. This corporation has been created under the state process, and you have given it limited liability that you as an individual cannot have. You as an individual cannot have. None of you as individuals can have. The idea of limited liability in corporation under the state process is a political decision has been made to encourage some kind of activity on the part of this other entity. And it actually gives more rights than you as an individual have, because you are able to actually limit your legal responsibility. So it simply doesn't make sense to me. Now, other people might make the argument, but what I would say is human beings have constitutional rights, period, full stop. Artificial entities created under the process, whether they are for-profit, non-profit, union, no artificial entity has the inherent inalienable constitutional rights that living, breathing human beings do. That's my position. So I had this gentleman, and then we'll come here, and then back to Wayne.
On your statutory rights, several states over the last several years have passed laws banning or outlawing gay marriage. Those were challenged in federal court, and the Supreme Court ruled that they were unconstitutional. So that allowed gays to be married. I think that was the most important law or decision last year, allowing gays to get married. But if another law had been upheld by the Supreme Court, would you consider that to be a constitutional right then, even though it was a statutory right to start with?
In terms of the right to marry?
No, not that. Not that. This is another law that it was challenged in the Supreme Court. The Supreme Court said that is legal. Would you say that is now?
I'm sorry, I'm not trying to be obtuse, but I honestly don't understand your question. So
okay,
right.
Say a law is passed, something to do with traffic or anything else, and somebody said that's not constitutional, and they contest that law in federal court, and the Supreme Court rules that law is constitutional.
So what I would say is this, sir, that the concept of constitutional rights, there is a time for courts to actually overturn the legislature. And you know when that is? If there is a clear and unambiguous showing that a human right is being violated. I'll give you an example of when it is appropriate for, quote, judicial activism to take place. Jim Crow segregation laws that go through a political process, and the majority says black people cannot move into, and I'll use property rights because this is the Houston Property Rights Association, black people cannot actually own land in this subdivision. I would argue that is, and it goes through a legislative pronouncement, and the city has actually created districts where that's not true. I would say that violates the inherent and inalienable rights of a human being. So that's an appropriate time to overturn a law. But here's the thing. I think that we have made a mistake today by immediately rushing into court and arguing constitutional rights just to get a result that we want, rather than applying the principles of a constitutional Republican form of government to the dispute. So when you ask me, if the court says it's a constitutional right, would I agree or disagree? I would have to say it depends on what the dispute is. There are some rights that are actually inherent and inalienable human rights that the legislature, whether it's a local ordinance or the county government or the state government or the U.S. government, Congress, with a presidential signature, cannot violate. So it just depends. Go ahead.
One thing, Marco Rubio has said more than once that all of our rights come from God. I think that's a bunch of nonsense, and I wonder what you think about it.
Well, what I would say is this. As the grandson of a Baptist preacher, I absolutely respect and believe and take him at his word that Senator Rubio actually believes that. So I'm not going to quibble with a person's faith. I will say this. I do believe that human rights are above government. And whether one thinks that those rights have come from God or the goddess or the cosmic accident that brings, or what is it, the flying spaghetti monster, for those of you who know that joke, regardless of how it is that you think that as a human being, human beings do have constitutional rights. So I'll respect that Senator Rubio believes that those rights happen because he was endowed with them.
God's never put any laws on paper. It's all been done by people. So
fair enough. So what we're going to do is, this gentleman has waited patiently. We'll go here, and then because we haven't heard, we'll go here, here, and then back to you, Wayne. Okay. Yes, sir.
So your argument is that the limited liability concept of a corporation diminishes the collective liability, which is what government sees. Because I operate several corporations, and I could not operate my businesses without those corporations because the government wouldn't accept my signature on bonds. They wouldn't accept my signature to conduct business in the liability for individual environmental laws. I mean, I could go on and on about it. That I would gladly trade the incorporation requirement imposed on me by government for doing away with it.
Okay.
So I agree with you.
Okay?
And I want to get rid of my corporate income tax.
That's a political process, and there ought to be vigorous debate over this.
I'm down with it.
Yes, sir.
Without mentioning any specifics, I'm of the opinion that many so-called constitutional arguments nowadays and the violation of so-called constitutional rights are in fact not. It seems to be the ultimate crutch when somebody feels wrong to claim that it's unconstitutional, when in fact the Constitution doesn't address it at all. And the Supreme Court, rather than taking the case and making a decision, should simply say, that's not in our purview. You know, there are some questions on the national scene that the Constitution does not address.
That's called a political question. That is a doctrine of political question.
Yeah.
The courts can say that.
Yeah.
Yes, and they once did.
Right.
And it is worth noting that, for example, I would submit to you, because somebody did mention, I think it was you, sir, the Citizens United decision, I would argue this. The question of campaign finance is actually a political question, not a constitutional law question.
Absolutely.
And I think that it is worth noting that the Citizens United decision actually gutted the McCain-Feingold law. You know, John McCain, Republican, Russ Feingold, Democrat.
Signed by W.
Yes. I mean, it really, you couldn't write this any better, could you? I mean, what I'm getting at is there was basic consensus amongst the elected representatives to figure out some way to protect the integrity of the electoral process, right? Oh, and by the way,
Incumbent protection.
well, that's right. And we could go into that, and I would love to actually get into that. But again, that's a political question, right? But the point is this: campaign finance law is a political question. When the court imposes its will, they have turned a political question into a constitutional law question, have stripped our sovereign right as citizens to meaningfully participate in that process, turned us into mere spectators. So I think, especially, again, a bipartisan agreement that the McCain-Feingold law represented that showed over 80% of the American people actually supported it. By the way, the one thing that most Americans thought, McCain-Feingold didn't go far enough in restricting, and catch this, they were pissed about not only corporate money, not only the Koch brothers money, but Soros money and union money. They thought there was too much damn money in the process, whether you're on the left or the right. The American people actually, and here's the kicker, the American people are actually hungry for a genuine debate over principles and values and ideas. We rarely get a chance to actually see that, though, because of the corrupting influence of money in elections, is what I believe. But at the end of the day, picking up on you two, sir, I believe with you that the Constitution actually is specific, and to claim a constitutional right, you better damn well be able to show that there is somewhere in the Constitution that a right is actually being violated of a human being. So you got to follow up, and then we're going to go here
From
and here.
And because of that, the Supreme Court, in taking and considering those cases, is in fact unconstitutional.
He said it, not me. Yes, sir.
Since civilization started, especially since progressive democracy and during the Enlightenment, there's been a tension between those who own property and those who don't. And our Constitution was founded by those who owned property, and Madison himself expressed in several places, I could find in quotes, that he was afraid that the democracy that they were forming at the Constitutional Convention would allow those who he mistrusted, the rabble and the masses, to take property from those who had property. And our Constitution is really a form of protection of property. I think that still exists today very much in our politics.
Yes, sir.
Okay, so I should tell you where I'm coming from. I'm general counsel of an internet startup, and I also volunteer mentoring entrepreneurs that are starting up businesses. And we always incorporate or form a limited liability company.
Of course
Now,
you
I know
do.
the history of limited liability companies from England and the U.S. and around the world, and and I think it's very, very useful. It's just commercial utility to have an entity that, like Don was saying, you enter into these contracts and you want to make sure that the investor's liability is limited. And not only the investors, the employee's liability. So I think the utility of having a general corporation, not a special corporation like you said, but a general corporation, the utility is overwhelming and it's used everywhere around the world. But just because...
So before you
Yeah.
go any further, I just want to be clear, Ed, that first of all, of course, as a lawyer and as a general counsel, you would be engaging in malpractice if you did not insist upon the use of that. Secondly, I really want to point out, my critique is not around the existence of limited liability. My critique is over whether these artificial entities known as corporations have inherent inalienable constitutional rights. So that, like,
Okay,
so we're in agreement so far.
So let's go to that. I would say that those legal persons, corporations, have a right to due process. So for example, eminent domain, which has become an issue now with Donald Trump's candidacy, any property that's owned by a corporation should have the same rights and protection in an eminent domain proceeding as if it were owned by an individual.
I would agree with that as well.
Okay, so I mean, this is a slippery slope.
It's not a slippery slope. What I would say is this, that, and the reason, and for non-lawyers, stay with me because I think I can explain my understanding, but it's a question of standing, right? Because the corporation as an artificial entity does not actually own the property.
Well,
it does legally. I mean, you understand it, but it's important for non-lawyers to understand how standing works. In other words, like if we're all owners of a corporation, right? Really we own the wealth associated with that, the property of that corporation, right? Now, nobody is going to say that we're all collectively of one mind, deciding how to practice religion or deciding, the inherent inalienable rights of a human being. However, if government tries to take the property that we all collectively have some proportionate share in, there has to be a way to respect those property rights. And it should not be that each one of us must go into court one by one by one by one. Instead, there would be a general counsel or the corporate form would actually be the appropriate body to claim those rights. So it's a standing issue. So I would say, with respect, sir, that's not a slippery slope argument. That's actually an understanding of how standing works.
Okay, well, as Barry said, a corporation is like an association of citizens. And if an association of citizens under the First Amendment has a right to petition for redress, then a corporation, if it's a legal person, can, on its own behalf, petition for redress of some grievance.
Well, again, I don't agree with your premise that it is, like, Barry gave the best case example. I explained why I don't agree with the premise. I don't actually think that a corporation is merely an association and that association has all the collective rights of the individual.
Okay.
So we just disagree.
What Barry said was that it's an association of citizens. It's individuals acting together, and so it is ultimately the individuals. But I would say in response to that, I mean, I understand what you're saying, but churches are also corporations. They're not-for-profit corporations. Municipalities are corporations. They can file for bankruptcy. You can't blame, having a corporate charter does not give you the right to ignore the rule of law. You have to comply with the rule of law even if you're a legal person. And finally, I would say crony capitalism doesn't depend on the corporate entity because the individuals that own it can get the benefits of corporate welfare whether they form a corporation or not. So I think you're condemning the corporations for too much.
Well, I mean, again, with respect, sir, I don't think I ever condemned the corporation. What I've said is the court has illegitimately created the concept of corporations having inherent inalienable human rights. I've actually not condemned the corporation at all. You're putting words into my mouth.
Well, that could be. But the good thing about Citizens United is that Jeb Bush is the biggest beneficiary of Citizens United because he was able to raise $100 million worth of PAC money, which is proving to be totally useless. thereby helping to rebut this idea that there's too much money in politics. There's too much money in politics, and it comes from the left and the right. But in politics, you need a good candidate, a good message, and then enough money. So I wouldn't get so excited about, the idea. You were concerned about there being too much money in politics, and a lot of people are. But I would say I wouldn't be too worried about that.
So we're coming to the end. Is there anybody who has not made a comment that would like to? So let's do one more round. We'll go 1, 2, 3, 4, 5, 6, please, 7. Please be brief because we are really at the end of our time. And if it's just a comment, then I just won't reply. But if you have a concrete question, I'll make it. Number
Okay.
1.
And I just want to make a statement about some comments I'm hearing. And again, there are the rules of life, and the rules of life are your Constitution. The federalized education system has taken civics out of our education, beginning in 1860, and by 1950s it was totally removed from our education system. Civics is different from American government. Everybody here that graduated after 1950 had American government typically, okay, not civics. Civics is about human rights, your rights as an individual, and that's where the Constitution comes from.
Unless you went to France.
And excuse me?
Unless you went to France.
Well, yeah, it depends. But I heard a question about marriage, and government was not involved in marriage until the Civil War, the federal government. And it was a law passed to prevent the mixing of colored races, marriage and colors. That's what was brought out. It was eventually extended onto all American people. So as far as it being a government question, it was never to begin with, had anything to do with your government. Marriage was between your church and your community. It was called common law in the old days. And as far as the corporation comment about the advantage and disadvantage, a corporation can come in, do horrendous harm to public, and you hear about this, that corporation gets dissolved, and then the people go back and they reform in another corporation and do the same thing over and over. What that has replaced is the private business. And when you have a private business, you are putting your neck on the line. Where right now, under a corporation, I'm putting this imaginary entity on the line. The limited liability corporation was created recently because the courts were taking the executives, throwing them in jail.
Don't want that.
And they got upset about that. So we came up. Excuse me?
And the investors.
And right. So they hold it.
So we have 7 people who would like to make a comment in the closing.
Okay, sorry. I know I talked too much. But
Number 2.
Anyway, so that's the whole point. Is have a corporation, but you need to have it responsible for yourself, like it was in the old days, where it went all the way up to the top. The owner, if the company messed up, he was at fault. Sorry, I talked too much.
Number 2.
The New York Times has an editorial today deriding a Supreme Court decision which allows Karl Rove's PAC to keep all the donors' names.